to be able to consult with the evidence leaders, to put information to the evidence leaders in order for the evidence leaders to then convey that to Mr. Van Rooyen and to the chair, and to clarify any remaining issues that are not covered. We think that it's more efficient if his legal representatives were allowed, even if it were 15 minutes, if necessary, to put the few questions which remain and to ensure that all of the bases are covered. That is what Mr. Mzuvukile seeks. He does so on the basis of the following principles. The first is in terms of the regulations that govern this commission, and in particular Regulation 6, which is that any person appearing before the commission may be assisted by an advocate or an attorney. Regulation 8 sub 3 provides further that any witness appearing before the commission may be cross-examined by a person only if the chairperson permits such cross-examination should he deem it necessary and in the best interest of the function of the commission. It's Mr. Mzuvukile's submission to the chair today that it is necessary and it is in the best interest of the function of the commission. He does not believe that he has a right to cross-examine. He is seeking the leave of the chair to do so on those bases. Regulation 15, of course, provides that the commission who may determine its own procedures. It's what we refer to as the broad discretion that resides within the chairperson. And again, in the rules, there's an echo of what is provided in the regulations. For example, in Rule 3.7, which provides that in accordance with Regulation 8 sub 3, there is no right to cross-examine a witness before the commission, but the chairperson may permit a cross-examination should he deem it necessary and in the best interest of the work of the commission to do so. Again, Rule 7.2 echoes the regulations that a witness may be assisted by a legal representative. In our heads of argument, we've referred to some case law. We've referred to, for example, State versus Sparks, which sets up the general principles about the function of the commission and procedures before the commission and the fact that it's not bound by rules of evidence and pleadings in the same way that a court of law is. We've referred to the case of Pergamon Press, which was cited with approval of the SEA in Jafria, about the importance of flexibility of the commissions of inquiry when the commissions deal with procedural aspects. The third case that we refer to is the PT1 case, and that's specifically the judgment of the High Court, in which the High Court found, and this case concerned the Americana Commission of Inquiry and the right to legal representation in the Commission of Inquiry. And what was important there, which we're not seeking here, of course, is that involved the right to legal representation at the expense of the state. That's not at all the issue here. It's merely the right to legal representation. And the court found that Section 34 of the Constitution applies to commissions of inquiry. Justice Maqetuka said that in the context of that application, it's of no consequence that a commission is not of a judicial or quasi-judicial nature, and that in each commission, regard should be had to context-specific factors. And he sets up the factors. I want to take the chair to do it. In the interest of time, they are contained in our basic argument. The principle really is that of the importance of flexibility, that it need not matter that the Commission of Inquiry is not of a judicial nature, that there is a right of legal representation, and that the factors that may apply are set out in the judgment. That test, of course, was endorsed by the Constitutional Court in that matter. We submit that right, that Section 34 right, in the context of the Commission of Inquiry, for it to be meaningful, it would require that a witness is able to exercise his rights through his legal representatives where appropriate. The penultimate topic that I want to address.
I think you are left with about 2 minutes or 15 minutes.
I'm going to speak up, Chair. The next topic is that the cross-examination of witnesses by by participants in an inquiry is not unprecedented. Again, these are set out in the heads of argument. I made reference to the Marikana Commission of Inquiry. I do not suggest that this commission ought to replicate the procedures that were present in the Marikana Commission of Inquiry, but there are principles that emerged from the Marikana report, which we refer to in the heads of argument, that are instructive, and that is in a way supporting what I've already set out in PT1 about the fact that there isn't a bliss between two people in the Commission of Inquiry does not mean that the right is ameliorated in the right to legal representation. I'm going to leave it there because the extracts are in the heads of argument. We say that it should be allowed in this case in the interest of justice and in the interest of function of the Commission. We would like to refer to one final judgment, which is again in order to guard against any errors and to protect the integrity of this commission. We refer to the Arms Deal Commission case, and that is Corruption Watch versus Arms Procurement Commission and others. And what I would like to draw to the Chair's attention is paragraph 53 in particular, which speaks about the role of evidence leaders. And I think that is important because it does become unclear at points what the role of evidence leaders are in cross-examination and not. There is a risk that evidence leaders might be seen as biased or favoring one witness over another, and that can be guarded against by affording, in our case we say, particularly with regard to paragraph 1.8 in terms of references to the ZA with its own right to cross-examine.
Well, in that regard, one must also bear in mind, I think it's the rule 3.2, which says that an evidence leader is entitled to ask questions to the witness that seek to establish the truthfulness of the version that the witness gives. Obviously, there must be looking at different versions, and there are different versions from different witnesses. So one has got to bear that in mind, that whatever the line may be between cross-examination and questioning a witness with the view to establishing the truth or the truthfulness of his or her version or the version of another witness, there is that particular point being made in the rules. So I'm saying one has got to factor that into account. So the evidence leaders shouldn't, seems to be afraid to ask difficult questions to a witness, just because they think the witness or some people out there are going to ask them of going under with a certain version, or because they are against a certain witness or certain categories of witnesses. They must have courage, they must seek the truth, and they must do so in the best way that the rules, the regulations, and our system permits. So where the line it may be that it's the same thing as cross-examination, I'm not sure, but whatever line may be, it probably is a very thin line. So I was just saying, in the context of all of that, one must bear it in mind.
Indeed, appreciate that, and I appreciate the guidance that you just provided on that particular rule. And it's correct, it's the role of the evidence leaders to find the truth and to not be afraid to go into lines of questioning that are necessary in order to elicit the truth. There may, however, be aspects of evidence that's not within the evidence leaders' remit because it is more about protecting the rights of a particular witness than it is about the facts that are being questioned. But in this case, what we are also saying is that Mr. Mzuvukile is a peculiar witness on this particular paragraph. He is the one with the most direct knowledge of what took place that day. And he wishes to assist the Commission. It's not merely to protect his rights, but he also wishes to assist the Commission in the event that there are, in order to leave no stone unturned. That is what he says. Finally, then in closing, Chair, I say that the granting of the application would not affect, would not undermine the role of the Commission's legal team. It's not intended that the application will preclude the Commission's legal team from questioning Mr. Van Rooyen. As I submitted already, no intention to supplant the responsibilities of the legal team, or that the intention of this application is for Mr. Pazile's legal representatives to be provided with an opportunity to supplement questioning when necessary. This may not be necessary if after the Commission's legal team has put questions to Mr. Van Rooyen, there isn't any stone that has been left unturned. And we submit, therefore, that in the interest of fairness, that such an opportunity be afforded, even if it may ultimately not be exercised. Those are our submissions, Chair.
Thank you, Mr. Maqetuka.
Chairperson, this application of Mr. Mzuvukile is made in terms of Rule 23.3.6. That much is claimed from paragraph 7 of his founding affidavit. Now, it is not common cause, but Mr. Mzuvukile is not an implicated person. So that issue is done and dusted. The only question that remains is, if he is not an implicated person, then in terms of what rule of the Commission is related to this application, in the heads of arguments, my learned friends, Mzuvukile's legal representatives, what they now do is they tell this Commission in paragraph 7 that Mr. Mzuvukile is no longer persisting with his application in terms of rules 3.3.6 and 3.4. They say he's coming before this Commission in terms of rule 8.3 and regulation 8.3 of the regulations of the Commission, read in conjunction with rule 3.7. Now, here's a study problem, Chairperson, in this issue. The first thing is, an application is made on the basis.
I'm sorry. Shall we agree that 15 minutes would be enough for you as well?
Yes, definitely.
Thank you.
It might be short now.
Yes, thank you.
Chairperson, an applicant comes before this Commission in terms of the particular rules of the Commission. And then he makes a reference to regulation 8.3 and 3.7, merely demonstrate that of discretion. But now, when he realizes that his applications are tenable, in the heads of argument, they now make a U-turn. They say, we're not making an application anymore in terms of that regulation and those rules. We're now making the application in terms of regulation 8.3. That is not acceptable outside. Nevertheless, assuming it were acceptable, I suggest we look at that regulation 8.3. My submission, first and foremost, is that regulation 8.3 is not an application regulation. It has nothing to do with making an application. It does not tell who can make application for leave to cross government. Neither does it deal with the requirements which such person must satisfy. There are only 3 things that rule that regulation deals with. The first thing is, it says any witness appearing before the Commission may be cross-examined. The second thing is, cross-examination will only take place if it is permitted by the chairperson. And the third is, the chairperson may and in the best interest of the function of the Commission. Now, in order to know who can apply, when they must apply, what requirements the application must meet, one needs to visit the rules of the Commission. Now, the rules are here to govern, and the title rules govern. There are not rules that are there to be ignored when you want to and go through another commission. There are rules to be complied with. There are information to the public that says to the public, this is how we can approach the commission. This is the procedure you need to follow. This is the period within which you must do it. And this is what you must satisfy for your application to be considered. Now, what my other friends today are suggesting, now, you can make another application independent of the rules and merely approach the commission in terms of regulation. I submit that argument is not that untenable. It's untenable if Mr. Mzuvukile sees that he has not been able to make out his application for the commission in light of the aspect of marriage. There are only two options available to him: he withdraws the application or he agrees for the application to be dismissed. And they are not doing that today. They want to proceed with the application, and he proceeds with this application. Now, one other thing that emerges today for the first time is that now Mr. Mzuvukile is claiming Section 34 of the Constitutional Right. He's saying that that much appears in the paragraph 21 of the heads. They say we submit that the right to a fair hearing in Section 34 of the Constitution requires the Commission to permit cross-examination of Mr. Van Rooyen by Mr. Mzuvukile's legal representatives in the interest of justice and in the best interest of the function of the Commission. The test, therefore, is whether such cross-examination will be in the best interest of the Commission. So there is a contradiction in that statement in the first place. Because if it is a requirement of Section 34 of the Constitution that the Commission must permit cross-examination of Mr. Van Rooyen by Mr. Mzuvukile, then what? Then if that is the requirement, so why are they saying that there was discussion? It's a contradiction there. Because they say it's a requirement of Section 34 of the Constitution. But it must be considered. He must be given permission to cross-examine. So their requirements of this application are now founded in Section 34. Again, this is different from the founding affidavit and the employment affidavit of Mr. Mzuvukile. Now, there is, we refer in paragraph 44, we refer to a judgment of the Constitutional Court. Only the one in Mabadi Wana and others, the President of the Party of South Africa. I refer only to paragraph 14, which says, Section 34 deals with disputes that can be resolved by application of the law. The Commission's findings are not necessarily to be equated with the resolution of legal disputes by a court of law. But the first thing Chairperson here is, what is this dispute that Mr. Mzuvukile has with Mr. Van Rooyen that he wants to see resolved? Even before we come to deal with whether or not Section 34 applies to him, there is no such dispute. He himself said in his own affidavit that I came to the Commission because there was a subpoena to come and get data. And he says he gave a statement in 2018, and then he gave another statement in 2019. Now he has given oral evidence before the Commission. Now after doing all that, he then says, I would rise in Section 34 for a fair hearing so that my dispute can be resolved. I'm not aware of this dispute. No case has been made on any of the papers for any dispute that he has. And I submit that argument must be dismissed. Now, I'm going to go to the further argument, Chairperson, and that relates to very well. It seems to me that it is accepted that Mr. Fuzi has not satisfied the requirements of Regulation 3.3.6. That, I don't want to belabor an argument on that aspect because it's clear that it is accepted. The interesting thing is that he still makes the application in terms of Rule 3.7. Now, Rule 3.7 does not stand alone. It stands as part as a sub-regulation, a sub-rule of Rule 3. That is being ignored. Now, Rule 3 tells us who can apply, who must, when they must apply, what the requirements are, and then it tells us what kind of leaves they can seek from the Commission, to give evidence, to cross-examine, and all that. So, there's no way, therefore, that you can look at Rule 3.7 independent of Rule 3. There's no way that you can cut it out of the rules and then say it's an independent rule in terms of the apply. In any case, all it deals with is that the right to cross-examine, no one has the right to cross-examine. You have to ask the Commission. That's basically the context. And the first back to Judicial Inquiry. So, Chairperson, I submit that this application, which in the one which is an abuse of the process of the Commission, is a delay for important work of the Commission. How can Mr. Fuzi come to this Commission after he has been given a chance twice, after he has been given written statement and followed evidence? How can he then come before the Commission and say, I now want to apply to cross-examine the implicated person? What interest does he have beyond that of being a witness who has given information? We hear from the legal representative today that they didn't have extensive consultations with him. Therefore, in other words, it looks like it deserves information that it doesn't give the Commission, and then it's that it can only give to legal representative. So that cannot be accepted. If you have any more information to give, you must come to the Commission to give the Commission. So, I therefore submit, Chairperson, that this application is at best ill-conceived, and at worst, an abuse of the process of the Commission.
Thank you, Mr. Maqetuka. And Mr. Halley, you might have something to say. I propose to give you not more than 5 minutes.
Thank you, Mr. Chair. Can I first address the question that you asked me about the use of the MICA's podium?
Yes.
I've just been provided with a part of a protocol
Yes.
of the Commission, which has been prepared by the Acting Secretary, and it says that provision of a separate mic for the legal representatives of the witnesses / implicated person must be ensured. So it's in that context.
That has not been approved by me.
I see.
That has not been approved by me. Yeah.
But it's, I think, on that basis that I was told.
Yeah, no, I have not approved for that. Yes.
Chairperson, just very briefly, insofar as this application is concerned, I was trying to listen to see what is the basis of the application. The application has
One second, Mr. Khalid. The lighting is not as good as it should be. I don't know whether it's because of this light that I see it being darker.
I struggle to see myself.
Well, I think the technicians will try and improve the lighting if possible. Okay, let's continue.
Thank you. At the end of the day, the application might have evolved over the passage of time between the draft of the papers and, of course, the argument that is now being presented. We would say that on the basis that the application has been brought and is now presented before you, Mr. Chairman, we will not support the application. That understanding the application has evolved into really an argument about the protection of the integrity. Certainly, it's particular business that happens to be tendered would be protected in that process. And insofar as there's been an argument about whether the application ought to be brought as it was initially in terms of Rule 3, alternatively now as it's been presented to you, Chairperson, in terms of regulation, we would think that it's of no moment as long as the party has not been prejudiced by that, and as long as the requirements that have been demonstrated, the requirements for the particular rule or regulation, as the case may be, have been satisfied, there would be no reason why an application which has been proposed to have been brought in terms of Rule 3, and then later on is brought in terms of regulation 8.3, should not be further. I mean, provided, as I say, that there's been no unfairness that has been brought to bear on the other party. We can see no unfairness in the present circumstances. It said that we don't believe that an application brought under Rule 8.3 of the regulation has been properly made up in this case. The integrity of this position should be amply protected by the evidence needed. And we would, if we can, as a matter of, in order to assist you, Mr. Chair, we would say that the application should be refused. We do not think that is properly done.
Thank you. Maybe before I go, I give Council for Mr. Mzuvukile the opportunity to respond. Let me ask whether Mr. Maqetuka has anything to say arising from this, so that when Council for Mr. Mzuvukile says something, he is the last one of Council to say something.
Chairperson, I was struggling a bit here, Mr. Hardy. Am I correct that he suggested that in order for the integrity of Mr. Mzuvukile to be protected, they have no objection?
He says, as I understand him, he says that he doesn't see any problem if he doesn't think that if you have brought an application in terms of the rules, you are precluded from bringing it or relying on the regulations afterwards. He will not, if I'm interpreting it correctly, he's not nodding so far, I'm not interpreting it correctly, but he, apart from that, he has submitted that the proper case has not been made out for the Commission for me to grant leave. But I think because I may have misinterpreted him, I'm going to allow him to come to this end and maybe take off for a few minutes, yeah, so that they can hear.
Thank you, Mr. Sorry. Yes, we misunderstood what the submissions that we do not support the application report by Mr. Mzuvukile. We will say.
And just raise your voice.
We do not support the application that has been brought by Mr. Mzuvukile. We say that Mr. Mzuvukile has not made up an application to be permitted to cross-examine Mr. Van Rooyen. His primary concern appears to be about the protection of his integrity. We would submit that his integrity would be amply protected by the process that will be dealt with, the questions that will be asked, and we would hope that the integrity would be protected, either integrity or anybody's integrity would be protected by the process of trying to ascertain the truth. And we as the evidence leaders are under a mandate and a duty to ensure that we ask questions to ascertain the truth. So that should be amply protected. His integrity should be amply protected in that process.
Okay, thank you. I don't think you will have anything to.
In that regard, all I can say, I'm okay, and nothing to that.
Yes, thank you. Council for Mr. President.
Thank you, Chair. I must correct characterization by my colleagues that the application is merely to protect Mr. Mzuvukile's integrity. That is a part of it, no doubt. But I was at pains in my earlier submissions to point out that it is also about the ambit of paragraph 1.8 of the terms of reference and the peculiarity of Mr. Mzuvukile as the witness before the Commission, in that he is the one with direct knowledge of the events over those 4 days that are at play, particularly the appointment of the 2 advisors. So it's more than that, and the point is to say, in order to leave no stone unturned, he would be of assistance.
Shall we agree on it? I should give you 5 minutes.
I'll be just 2 more points.
Yes,
1 minute would be sufficient. Just in relation to the rules, of course the rules govern, as they say, the proceedings, but the rules are not to be applied inflexibly. And that's understood and appreciated by the rules itself when one has regard to Rule 11.1, where there's an open-ended rule which says anything that is not governed by this, any application that is not provided for any of the rules may be brought as long as it's brought with adequate notice. So I just want to correct that understanding that the rules are not as inflexible as might be suggested. And then finally, with regard to Section 34, the whole point of the PT1 case is to say, yes, it is unusual because there is notice, but that does not mean that it has no application. It's the paragraph 37 of that judgment is the paragraph I refer to the Commission to. Thank you.
Thank you very much. I'm going to reserve my decision, and the parties will be, not the parties, all consent will be notified as soon as it's ready to be handed down. So I think what we will have, we'll have one short matter where counsel need to say something that's going to be 2-3 minutes. So after that, I will adjourn to allow counsel to leave who are not involved in the evidence that will be left for the day. So I think that I'm expecting counsel representing Ms. Jane, who was supposed to appear before the Commission yesterday, and I postponed that today. So Mr. Harding might have something to say before counsel for Ms. Regini say something.
Thank you, Mr. Chairman. This is the matter where Ms. Jenny Musani, having granted leave to cross-examine certain witnesses, as I understand it, she has given an indication to the tribunal.
I'm wondering whether, because Mr. Maqetuka complained that he could not hear, I wonder whether for the duration of what you say you might. Yes. Okay.
This, Mr. Chairman, was an application that you had approved. It was an application brought by Mr. James Musani to cross-examine a particular witness who had implicated her. And I believe it was a Mr. Naidoo that implicated her. And she had written to the Commission reportedly to withdraw her application. We had made contact recently through an attorney recently to ascertain whether she was going to come to the Commission anyway, because she could not be released as such, having brought her application. We understand that the attorney has made arrangements with the junior counsel to come to address it on the issue. I understand that he sent that to Duncan Wow.
Okay, thank you. Counsel for Ms. Regini. Thank you.
Duncan Miles, instructed by Webwensel for regaining some.
Yes.
As Mr. Ali said,
they don't hear you.
Yes, thank you, Chair.
Yes.
Also, I can't see with this mask on because it misses my glasses. Both wrong.
Yes.
Yes, Chair. So it concerns two applications that Mr. Nsami brought with regards to evidence of Mr. Kobus Rolofsa and Colonel Dhanajaya Naidu to cross-examine both of those witnesses. You granted both those applications, one on the 3rd of December last year and the other on the 5th of March this year. In the exchange of affidavits that happened after 3 December, it has become apparent to Mr. Nsami that those two witnesses have no direct evidence of her wrongdoing, and she has set out her version comprehensively in her own affidavits. Moreover, she remains willing to testify, and she will make mentions of the evidence because, but for those reasons, and the fact that she does not have the financial resources to involve lawyers in preparing the cross-examination, she wishes not to persist with those two applications and not to cross-examine anymore, but she does remain willing to give evidence if required by the Commission.
Would it be a correct understanding of her position that from her point of view she abandons the right to cross-examine those witnesses insofar as the chairperson has granted her the right to cross-examine them, but if the Commission would like her to come and testify, she is happy to come and testify?
That's exactly right, Chair.
Yes. Okay, no, thank you very much. I think she will hear from the Commission once they have reflected on the developments, and if there is a wish that she should come and testify, she will be contacted.
Thank you very much, Chair.
Thank you. I will then adjourn for a few minutes to enable council who need to leave to leave, and then we can resume to continue with the business of the day. I'm going to take a 10 minutes adjournment. I'll come back at 10 to 11. We adjourn.
All rise.
Are you ready?
Yes, thank you, Chair.
Yes.
Chair, you will recall that Messrs. Sheikh and Njenje gave evidence in relation to state security matters. The third witness in that category of witnesses is Ambassador Maqetuka, and he is here to testify. You have a bundle before you, which is Exhibit PP3, which contains his statement and certain additional documents as set out in the index.
You haven't appeared before the Commission for quite some time.
Correct.
Something that has been happening, and it's not cast in stone, and you can make your own contribution to it, has been an approach that says the actual exhibit is the statement and the annexures to it, and that the box, the file, is not the actual exhibit, and that it's convenient to call it bundle so and so. But when we refer to the exhibit, we actually refer to the statement or affidavit or annexures. That is not finalized, but it's something that has been happening.
Yes, Chair. There's a saying amongst the legal team that everybody who appears for the first time must go through the bundle baptism. It seems that I'm going through it too. I'll change the word exhibit to bundle.
Yeah, okay, all right. But of course, the bundle would have to have its different, like bundle S or whatever, and then the exhibit can remain, the affidavit can remain as exhibit PP3. So,
actually, Chair, it's nothing that should be made light of, because when the record is finally prepared, it should be consistent, accessible, and comprehensive. And if it's not and it's confused, it's going to create big problems. Down the line.
That's true. So you can later on, I think, reflect on it, but so long I will take exhibit PP3 to refer to the actual affidavit and the annexures.
Yes, thank you, Chair. We'll fix it up and ensure that there's a consistent scheme.
Yeah, okay.
May the witness...
yes, please administer the oath of affirmation.
Please state your full names for the record.
I'm Mzuvukile Maqetuka.
Do you have any objection in taking the prescribed affirmation?
No, I don't.
Do you solemnly affirm that the evidence you will give shall be the truth, the whole truth and nothing else but the truth? If so, please raise your right hand and say, I truly affirm.
I fully affirm.
Thank you very much. The lighting is worse than it was before. I think there is a light that has been switched off, which was on earlier. Particularly the witness, I could see when he was standing, and I'm sure when he's sitting, it's very dark where he is. I think they are going to switch on that light. I don't know if it disturbs anything or it doesn't. Mr. Pretorius, I think it's taking longer than they thought it would. Maybe Reverend Stemela is going to tell you something to say whether we need to adjourn or not, to get them a chance to.
I'm told, Chair, that the light switches are locked away behind a door and the key needs to be obtained, and I'm told 5 minutes will do it.
Shall we adjourn for 5 minutes?
As you please, Chair.
Or do you think we should continue?
I'm happy to continue. Ambassador?
I'm fine.
Yes, okay, maybe let's continue. Once they are ready to fix, they will tell Reverend Stemela if they need me to adjourn, or if they are able to switch it on without us adjourning, then we will continue. Okay, let us continue.
Thank you.
Before we do so, Ambassador Maqetuka, I just want to thank you for coming forward to assist the Commission. You would be aware, I'm sure, that since 2018 I have been calling upon past and present DGs of different departments and ministers and deputy ministers and other officials in government who know something that this commission should be told to please come forward and do so. A number of ministers or past ministers and DGs have come forward. I remain concerned that I should have had from many more than I have. I hope that there will still be some who will come forward, but I really want to express the Commission's appreciation to you that you have come forward to assist the Commission with what you know. We really appreciate that very much.
Thank you very much, Chair.
Thank you. The one thing that you must assist me with is whether it's Ambassador Maqetuka, or because I'm not clued up with some of these titles, but I know when General Nyanda was here, he told me that once a general, always a general. So, but I want to use the right title. That's the bottom line.
I'm told, Ambassador, that the title remains.
It's the same with the generals.
It's the
Chair.
same as the generals?
Yes, Chair.
Okay, thank you, Ambassador. Yes, Mr. Pretorius, you may proceed.
Thank you, Chair. Ambassador, you were formerly employed as the Director General of the State Security Agency. Is that correct?
Correct.
When were you appointed?
I was appointed in 2009, October 2009.
And you retired from the service when?
I retired from the service on the 28th of January 2012.
You may keep your mic on, Ambassador, and if you want to move it a little closer to you so you don't have to move forward all the time, that would be fine. Thank you.
Thanks, Chair.
During December 2018, you signed a statement which we will refer to as your first statement, and that's annexed as Annexure MM1. Is that your first statement?
Is that the one after the affidavit?
Yes, marked MM1.
The MM1 would be those blue dividers that, well, they are blue with mine. I'm assuming they are blue with your file as well, but they might be a different color.
Unfortunately, I only have one divider here, which is marked 2.
Oh, I'm sorry, Ambassador. It's
MM1.
important that you have exactly the same thing as I have and as Mr. Pretorius has. Maybe Mr. Pretorius, I should adjourn to get that fixed because it will give us problems throughout.
So, thank you. I know I got it, Mr. Pretorius.
You have it?
Yes, I have it, Advocate.
Yes. I'll refer to page numbers in due course, and during the short adjournment we can put the dividers in. Chair.
Okay.
My apologies, that should have been done.
Yes, okay.
In any event, you did sign a statement in December 2018. Is that correct?
Yes.
Ambassador?
Yes, sir.
And if you go to page 24 of the bundle now in front of you, it'll be page 24 or 25. Is that your signature?
Yes, it is.
And you've confirmed by affirmation that this is your statement. Are you satisfied that its contents are true and correct?
Fully certified, Advocate.
If we go to page 2 of your statement.
Mr. Pretorius, I'm just trying to have a look here. Oh, okay, now I see what the position is. I think what happened is my staff put the unsigned affidavit that I got much earlier in as well, but the signed one is there, but I was looking at the unsigned one, and page 24 of it doesn't have his signature, but that's because I've got two 24s. But there is a page 24 which has got his signature, so it's fine.
Thank you, Chair.
Yeah.
If we can go to page 2 of your statement, Ambassador.
Yes, I'm there, Advocate.
You will see there set out the 9 topics that you will cover in your evidence. We don't need to deal with this list in any detail, but in summary, I understand you will tell the Chair about matters relating generally to national security in its constitutional context and principles attaching to the practice of national security. Do I understand that correctly?
That's correct.
You will also deal with certain factual matters that were also dealt with by Messrs. Njenje and Sheikh in relation to Minister Twele and the former president. In relation, in particular, to the Gupta investigation.
Correct.
And you will also deal with certain other matters, and we'll explain them in due course, the Principal Agent Network 1 investigation, which we colloquially refer to as the PAN 1 investigation, and certain other matters, and ultimately your resignation.
Correct.
Because you are going to tell the Chair of your views and opinions arising out of your own experience in the field of intelligence, perhaps you would tell the Chair very briefly and in summary what your background and experience is in the intelligence field. You deal with that on page 3 of your statement.
Yes, sir. It's a long story, it's a long journey, Chair.
Yes.
But safe to say that I have been a member of the intelligence and security in exile, 1979, up until my retirement in 2012, basically. But of course, there were other functions in between that I did in various years during my tenure. But safe to say that from 1979, I had my military training in both Mozambique, Angola, where I had my full military 6 months training as a company commander. And I graduated at a camp called Pango. That would be now in 1980, run about June, July. From there, with 3 colleagues, we went for a specialized training in the craft of intelligence in the then German Democratic Republic, the GDR as it was called. We had a 4 months training, intensive training in intelligence and in the craft of intelligence and counterintelligence. I returned from the GDR run about October, November, and went back to Angola, transit to Mozambique. This now is 1980, Chair. And immediately after my training, I was then fully incorporated into the structures of what was then called the Department of Intelligence and Security, popularly known amongst us as DIS.
For how long were you working with DIS?
As I say, I can safely say from 1979 up until amalgamation of the 6 South African intelligence services. You will recall, Chair, as part of the outcome of the negotiations, South Africa by then had 6 recognized intelligence services. One was the National Intelligence Services of the apartheid regime. Then there was the Department of Intelligence and Security of the African National Congress. Then there was the Bophuthatswana Intelligence Service, which was a BIS. And then there was the Venda Intelligence Service, VIS. And then there was the Transkei Intelligence Service, TRIS. Those 5 services were the services that were recognized as services that would be integrated into a future South African intelligence dispensation. I can also safely say that later we were joined also by the PAC, because you would recall that the PAC joined the negotiation process slightly later than the rest. But ultimately they joined and they were integrated into the process. Therefore, that is why today we safely say that there were 6 intelligence services that were integrated in what would be called today your National Intelligence Agency, that is NIA, and all the others, which I'm sure we will deal with it later.
Thank you, yes.
You have said that you started your training in 1979. Did you say in Germany?
The orientation into that training actually started at the beginning, January 1979 in Mozambique.
In Mozambique.
But
yes.
that was not your fully fledged training, it was
Yes.
orientation.
Yes.
The training, the full training started in Angola
Yes.
in January 1980.
Yes.
Chair.
Now, That was obviously not training.
In intelligence.
Was it not training in intelligence?
No, it was
Angola.
It was a military training.
Or military training, okay.
Yes.
Were you undergoing that training by reason of being a member of any freedom or movement or party that was fighting for freedom?
When I went to exile in 1979, I joined the African National Congress. And the training that I will be talking to and that I'm talking to, Chair, would be under the auspices of the ANC. And the military training within the ANC was under the auspices of Umkhonto Wesizwe.
Yes, no, thank you.
Yes, and the specialized intelligence training you've referred to took place in 1980.
1980, the specialized ran about June, July. Actually, I've just been working over the past few days. I narrow it to have arrived in the GDR at the end of May, beginning of June. And how I managed to narrow that, just as a background, Chair, if you don't mind, was that in 1980, 31st of May, that's when a unit of Umkhonto Wesizwe attacked the Sasol and Netref plant. And that was on the 31st of May, 1980. And because, why I remember it so vividly now, it is because at the time of the attack, that was the week or the period when we arrived in Berlin. And a senior member of the national executive of the ANC happened to have arrived in Berlin, and he came to our camp to come and brief us about the developments inside the country and that Sasol attack. That's how I managed to remember it. But it's interesting to, if I tell you, Chair, that if you had asked me this question, say a year ago, I would not have remembered the dates. But I've been thinking about these things all the time and all the time. That's why now I'm specific and I'm in a position to focus it to a specific date.
Thank you.
You spoke a moment ago, Ambassador, of the amalgamation of 6 intelligence services into a service called the NIA, National Intelligence Agency, and the South African Secret Service as well.
Yes, again, as a way of short background, Chair. In 1994, May, I completed my studies in England. I completed my BA in in communications, specializing in photography, film, and television studies. And I came back in May 1994, which was the time when the negotiations were almost at the end, and subcommittees had already been established.
So when you talk about negotiations in this context that were about to end, you talk about negotiations aimed at integrating the various intelligence services.
Not only the intelligence services.
And not the entire negotiations for a new constitution.
It's the entire negotiations. But the relevance of this that I'm being asked by the advocate is in relation to intelligence within that broad negotiations for a new dispensation.
Well, I was asking that question because the first democratic election was on the 27th of April.
Yes.
1994.
Yes.
And as I understood what you were saying, you were talking about towards end of May or 1994, or did I misunderstand something?
I came back from my studies in May 1994. And by then, the negotiations, or let me not say, it's not the negotiations per se, the integration of these 6 intelligence services was behind the schedule. That is why I joined the integration, the negotiations for the integration of these 6 services in May 1994. But you are correct, Chair, it was after the elections by then.
Thank you.
Yes. I understand, Ambassador, that the 6 organizations were integrated in January 1995.
Correct.
And did you receive an appointment at that stage in the NIA, the National Intelligence Agency?
Correct. In 1995, I was then appointed as the Deputy Director General of the National Intelligence Agency, the old NIA, correct?
Right. And what was the essential difference between the National Intelligence Agency on the one hand and the South African Secret Service on the other?
Advocate Pretorius, ultimately, this integration of these 6 intelligence services were into the NIA, that is the National Intelligence Service, which was a domestic intelligence service, the South African Secret Service, which was the Foreign Intelligence Service. Then there was the South African National Academy of Intelligence, which was the training institution. Then there was the National Intelligence Coordinating Committee, called NICOC. That is in the nutshell, but I'm sure we'll come to
We'll come to that in due course. The various communications or interception agencies were separate at that stage.
They were a separate structure, but not a department. But it was a separate structure.
Anyway, to the extent necessary, as part of your evidence, we can explain that in due course.
Yes, I will.
But as Deputy Director General of the NIA in 1995, you then dealt with domestic intelligence.
Correct.
And in that capacity, you served until when?
I served as the DDG of NIA between 1995 up until 1997.
And after that, I understand, if I may just lead you on this, I understand that you served in various national government departments and finally as an ambassador in Algeria.
Correct.
When did you come back to South Africa and in order to occupy what position?
In 2007, I was appointed South Africa's ambassador to Algeria. That was 2007 until 2009, when I was appointed the Director General of the South African SSA, State
Security Agency.
State Security Agency.
Yes.
Yeah. Thanks, Chair.
It may become relevant later, but the circumstances which gave rise to your re-entry into the intelligence service in 2010 Would you tell the chair briefly how that came about?
Yes, I can. What had happened is that whilst I was on station in Algiers, I received a telephone call from the then Director General of the then Foreign Affairs, which is called DERCO now, to say that I will have to travel back home for consultations. There are matters that I am supposed to be engaged with the President and the Minister for Intelligence Service.
The minister then was?
Minister then was Dr. Siyabonga Cwele.
And the Director General of the then Foreign Affairs was?
The Director General was Dr. Ayanda Nsaluba.
Did you then return?
Yes, for the consultations. And of course, nothing was explained over the telephone what it was for. And I was just told that when you arrive in Pretoria, then you will get the full briefings. And indeed, I left Algiers, arrived in Pretoria, and of course, the first place of protocol was my department, which was Foreign Affairs then. I had a short consultation with DG Nsaluba, who then briefed me that actually you are needed by your former department, that is the intelligence, and that the Minister for Intelligence will brief you because I am not equipped to give you that briefing. What I am involved in is to facilitate because you are still a member of the Foreign Affairs. It was in that context.
Did the Minister Cwele brief you?
Yes, he did. I met with Minister Cwele, who welcomed me, and then he told me that there is a new agency that is being formed, and that there is going to be a reintegration of the two separate agencies, that is the National Intelligence Agency and the South African Secret Services and all other structures of intelligence would be integrated into one organization now, which became the State Security Agency.
That integration is a matter of some controversy in the evidence of Messrs. Sheikh and Njenje, and also in your evidence, which you will deal with in due course.
Yes, I will.
Did you then receive an offer from the sitting president?
Yes, because the minister then told me that you will have consultations with the president where now you will get the final details of what it is that the president wants. And indeed, I met President Jacob Zuma at his residence in Mahlabandlovu, and the president welcomed me and confirmed what Minister Cwele had said, that he intends appointing me. That is the language that is used, Chair, when you are appointed at that level. You are first told that it's an intention, because it's always subject to your acceptance or not acceptance.
So by the time you spoke to the former president, you had made the decision to accept the position, I understand.
Not at that stage, really, to be honest, in my mind, because knowing the processes, I needed a confirmation that indeed what Minister Cwele had briefed me is in tandem with what the president is saying. And of course, we always, and I knew that the president would not expect to get an answer immediately, let alone the fact that I was still an ambassador. I would still needed to go back to Algiers to be formally released by the president of Algeria. That is the protocol again. As an ambassador, you don't just leave your station. I mean, that is an offense to diplomatic and protocol.
Ultimately, we know, as you say in your statement, you accepted the appointment.
Ultimately correct.
Yes. And at the same time, we've heard evidence that Ambassador Sheikh accepted a position and Mr. Njenje too. What were the positions? Would you just describe them for the chair?
When we were formally introduced to the media, the minister held a press conference, which is again protocol. And before the press conference, then we were in a holding room. That's when I first met Sheikh and Njenje, right? Because at that time, I didn't know who else was going to be in this SSA. Then I met Njenje and Sheikh, we greeted each other, and then it came out that all of us didn't know what we were going to be. You know, can I proceed?
Yes, please.
Until the actual press conference. It was in the actual press conference that Minister Cwele then informed the public about our appointments, that I'm being appointed, I'm being appointed as the Director General of the State Security Agency, and I will be deputized by Ambassador Sheikh, who will head the foreign component, the foreign branch, and Mr. Njenje, who will head the domestic branch. I'm deliberately using the words heard, as I will explain later in my evidence, Chair.
Well, you say that you heard for the first time at the press conference what your position was going to be. When you met with the president prior to this, before you went back to Algeria, when he expressed his intention to appoint you, did he not specify the position to which he wanted to appoint you?
The president did.
Yes.
The president did.
Was it the same position that was announced in the press
That
conference?
was the same position that was announced.
Yes.
And if my memory even serves me well, if I recall back, as we were going to the press conference hall, I think Minister Cwele did whisper to me that the president has decided that you will be the Director General.
Yes.
But formally, and to all of us,
Yes.
it was only at the press conference
Okay.
that our designations were announced.
Okay.
You've touched on it already, Ambassador, and you explain in your
I'm sorry,
statement.
Mr. Pretorius. I say it's 11:30. We normally have tea at 15:15, but today's program is not going the way it normally goes. I think we must just agree when we will have a tea adjournment or whether we should not have.
In your hands, Chair.
I'm quite easy. Should we have 8 at 12 or should?
I'm happy to accommodate any time, Chair.
Ambassador?
I'm sure Ambassador,
I'll be led by you.
Yes.
Chair.
perhaps a comfort break for 10 minutes, Chair,
Yeah, about 10 minutes at 12 o'clock?
at 12 o'clock.
Yeah,
Sure.
okay, all right. Yes.
Ambassador, you've touched on it already and you will speak a little more about it, but at the time of your appointment as DG and accounting officer of the amalgamated intelligence service, your mandate was to arrange and facilitate that amalgamation, I understand it. Is that correct?
The integration, yes.
Now, in the course of doing so, the mechanics of that are contained in your first statement, or Annexure C to your first statement, and we're not going to deal with it here. That's an administrative matter largely. But what is important in your statement is the principled work that you did, and in particular your reference in paragraph 25 to the white paper on intelligence. We're going to deal with the contents of that white paper in some detail in due course. But what is this white paper on intelligence? When was it written and presented, and why is it, if it is, an important document?
In any government department, but in intelligence in particular, the white paper was developed in 1994 as part of that basket of negotiations. A white paper sets out the philosophy for intelligence, the structure of intelligence, the code of conduct for intelligence practitioners or officers, as we would say. That is the white paper. And we usually see it as the most important document, even more important than the legislation, because the legislation becomes more an operational guide. After the Constitution, let me also be clear on that, because it's important within the South African democratic dispensation that everything flows from the Constitution. That is why I think, if I'm not mistaken, you'll pardon me, Chair, I am not a legal expert. I know nothing about legal matters.
No.
Nor do I, but I've been educated by your team that there is chapter 198 of the Constitution, which really sets out matters of national security. So matters, and it is broad in the Constitution. It does not necessarily zoom into intelligence or military divisions and blah, 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 blah. But those would be contained, after the Constitution, those would be contained in the white paper. The guidelines, even in the white paper. And that is the relevance and the importance of the white paper.
You touch on that in paragraph 26 of
Well,
your...
probably, Mr. Pretorius, probably they probably didn't say chapter 198. They probably said section 198, Ambassador.
It's
because
chapter?
I know our constitution is quite important, but I don't think it has got so many chapters.
It should be chapter 3.
I suspect that they didn't say chapter 198, or they may have said section 198 or chapter 3.
It's chapter 3, Chairperson.
Yes, okay.
Yes.
Okay.
198 or 98, yes.
Yeah, okay. Thank you.
The context in which the white paper was developed, Ambassador, is important for your evidence later. You touch on that in paragraph 26. What was happening at the time, of course, is that one was moving from the old apartheid system to the new democratic structures set out in the Constitution. In that context, what was the importance of the white paper, and what was the importance of the transformation of intelligence?
The salient importance of that white paper, Chair, is that for the first time in the history of South Africa, the white paper made it very clear that the new intelligence dispensation, one would be a democratic one. And it went further to say the new intelligence dispensation shall not only concentrate on your traditional military security matters, but it will also deal with issues of human security. That is the well-being of its people. Now that is fundamentally important because it was for the first time. That's what the white paper stated, Chair.
Yes, you quote in paragraph 26 a section under the head Philosophy of Intelligence. Perhaps that might be read on the record. Paragraph 26, page 7 of your statement.
And that's at page 7.
The red numbers at the top.
Is it the red numbers?
Yeah, look at the
Page
red
7.
numbers, yeah.
Page?
7.
7.
Page,
Or
okay.
is it 6 or 7, Mr. Pretorius?
7. Well,
On mine is 7.
yes, it's 7 on mine too, thank goodness.
Okay. When he won't call 007, Ambassador, he will just say 7.
7.
But that's the numbers, red numbers on the top right-hand corner.
Yes, I am there, Chair.
Yes,
Pardon me.
yes. It may be that a similar lamp should be obtained for the area where the witness is. That
Yes.
might not be something that can be maybe obtained today, but going forward so that it's much more
Yes, yes, Chair.
lighter, yeah.
It's not very helpful there.
Yeah, yeah.
That extract in paragraph 26, would you read it onto the record, please?
Paragraph 26 of my statement, section 1 of the white paper sets out its objective, namely to serve as a framework for the understanding of the philosophy, mission, and role on intelligence in a democratic South Africa. This philosophy on intelligence is dealt with in section 3, sub-paragraph 3.1, where it is explained that reshaping and transforming intelligence in South Africa is not only a matter of organizational restructuring. It should start with clarifying the philosophy and redefining the mission, focus, and priorities of intelligence in order to establish a new culture of intelligence. That's what is encapsulated in the white paper.
You emphasized a minute ago the importance of the reference in the white paper to the new intelligence structure having to also look after the well-being of the people. May I ask whether that is something that accords with the international standards, or in some countries that may be democratic societies, or it was just something specific because it came at a time when South Africa was being democratized, and it was thought that it was important that even the intelligence community must know that the well-being of the people is paramount.
In my response, Chair, where I don't think we will and we should claim as South Africa that we were the only ones. It was informed basically by democracies in certain parts of the world, especially recall by then the Cold War had stopped. And this was informed by experiences from countries like your Canada, your Australia, your UK, who are very, very strong in this field and in this new mindset for intelligence.
Thank you.
You touch on this in paragraph 27, and we will then go to the white paper and look at the principles set out there, which you've touched on already, Ambassador. But when you and Messrs. Sheikh and Njenje were appointed, was there any clarification in relation to the philosophy, mission, or intelligence intended for the new to be formed SSA provided to you?
Not at all. There was none whatsoever.
Right.
That is why, if you may allow me, Advocate, I can read from my statement in paragraph 27, Chair.
You
And
may
I
do
can
so.
reconfirm that when we were appointed, there had been no opportunity for us to be reorientated or to be briefed. What is this new philosophy now that is being ushered in? Remember, we were moving now from a dispensation from 1994, and by and at that time, you didn't have an integrated intelligence. You had your separate intelligence services. Now you are integrating okay, before I move to that, that is now, we believe that there would have had an opportunity to discuss the philosophy for the SSA.
Right. And you say in paragraph 27 that in order to be guided in respect of that philosophy, you resorted to the white paper and the principles set out there.
Yes.
Chair, would this be a convenient time for a 10-minute adjournment? We're going to go to the white paper now, which is a new topic.
No,
and
that's
I'd
fine.
like to take this opportunity to put the dividers in the witness's statement.
Okay, so maybe we should make it 15 minutes?
As you please, Chair.
Okay, we'll take the short adjournment. It's 11:45. We'll resume at 12 o'clock. We adjourn.
Thank you, Chair.
Okay, let's continue.
Thank you, Chair. Ambassador, would you please go to Annexure MM2? They've now been marked in your bundle. And if you would turn to page 90, is that the intelligence white paper?
Correct.
The first paragraph reads, "This white paper is intended to provide a framework for the understanding of the philosophy, mission, and role of intelligence in a democratic South Africa." The Chair has asked you the question as to whether this intelligence white paper was guided by or influenced by international democratic practice. Do you have anything to add to your previous comment?
No, I don't. It was informed rather than influenced. It was informed really by them. Yeah.
Yes, and you've also explained to the Chair that this paper was developed against the background of a need for a new democratic dispensation.
Correct, sir.
Perhaps because it's reflected in the language of the Constitution, the distinction between human security on the one hand and state security on the other. It's a matter you've raised frequently in the past.
Sure.
What is the significance of that?
To me, I don't know whether it is a matter of interpretation, because I learned that in the legal field, it can be an issue. But in my interpretation, which I can safely say many of my colleagues agree with the interpretation, people like Njenje and Sheikh, that if you look at the pre-2009 new dispensation, everything was national. The National Intelligence Agency, you know? And we have grown into believing that this institution called intelligence, it's a national rather than a state instrument. Hence, we had a problem, and I'm still having a problem to understand or to accept that we have moved from national into state. So the immediate question, and we are still asking ourselves these questions, did the principals, that is the policymakers, did they really think through even on those two concepts?
Yes, Ambassador, some may say, well, it's just a name, but perhaps you can explain what is behind the distinction.
In my understanding again, and again corroborated by my other colleague, one of the challenges that we think happened in 2009, it was part of the problems that the country was ushered in by 2007, the Polokwane Conference and the change of regime. And that the new regime wanted to change everything that came from the old. As I say, it's a matter of interpretation, maybe, but they would be the best, what the Americans called the framers of our intelligence dispensation, that decided that it should be state rather than national.
On your understanding, would, on the face of it, the change from national security to state security in any way, on the face of it, I accept that there might be arguments to the contrary. On the face of it, would it resemble anything compared to what the focus of the intelligence under apartheid was, or not really?
I think, Chair, we will touch.
You will deal with that in
I
due
think we will
course.
touch with your question when we deal with the proclamation
Yes,
as an
okay.
example.
Okay, that's fine, that's fine.
But if I don't deal with it satisfactorily, maybe we can try and discuss other examples, but we can try.
Yes, yes, yes. It's just that you do emphasize, and you have done so repeatedly, and I must assume it's because of the importance of the issue. You do emphasize the change of the language from national to state, and therefore, because I've never been in intelligence, I want to understand why, in your mind, this distinction is so important. But I accept that for now, you might be able to clarify that later. So I just want you to understand why I was asking that question.
Thanks,
Okay.
Chair.
Yes. Well, perhaps very briefly for the present, it will come up later in the detail in the white paper. But in developing, in the words of the white paper, a remodeling of the moral codes and organizational culture governing the intelligence environment, the purpose of the intelligence community and structures, who must they serve?
The intelligence, like any structure of government, must serve the interests of the people, primarily. The state becomes the conduit and the oversight over its departments. Are they doing the right thing? Oversight bodies. And again, later, I think, Advocate Pretorius, we will deal with this issue of oversight bodies.
Yes, we're coming there now, yes. The paper continues under the head Philosophy of Intelligence to talk about the need to establish, and this is in 1994, 1995, the need to establish a new culture of intelligence. And references made to the prior intelligence services having been formulated by a minority government, and it was the aim of the white paper to redirect the intelligence community and structures to serving the national interest, as you say. In paragraph 4, mention is made of institutional checks and balances. That's an important component of this white paper and of your evidence and perhaps evidence to come. What were the institutional checks and balances introduced in the new dispensation, and why were they introduced?
One, there was the Joint Standing Committee on Intelligence, which is a parliamentary body comprised of all the political parties represented in Parliament. That was one of those institutions. Two, a new office was created, the Office of the Inspector General, which became or is supposed to be the ombudsman and a facilitator between aggrieved members of the service, but more than anything, public and interface on intelligence. Any member of the public, South Africans, can report anything that they find wanting to the Office of the Inspector General, because as the term of reference of that office are clearly spelled out, he has got unfettered access to anything that is happening in a particular, in the intelligence structures. I think those are the two most important oversight bodies for the functioning of intelligence that were created post-94.
And Chair, I might just place on record that the current State Security Service have expressed their willingness to testify and cooperate with the Commission. And of course, what happened in the intelligence services in the last period, covered by the Commission's work, is something that will test whether these principles contained in this white paper were actually carried out, and importantly, whether the oversight bodies performed their proper function, whether that be the Inspector General's office or the Parliamentary Committee. But that is beyond your time, as I understand it. You will touch on it with Pan 1.
Yes, it is.
The concept of modern intelligence, you discussed it, Ambassador, briefly this morning. The move away from simply protecting the borders from foreign invaders, and that being the purpose of intelligence, to a more modern concept of intelligence. It's dealt with in the last paragraph on page 92. The forms of intelligence, what areas intelligence must cover. If you would refer, please, to the last paragraph under paragraph 3.2 on page 92.
Is that the one starting with intelligence may be gathered?
Yes.
Okay.
You can read it if that's more convenient.
Yes, no, I would prefer to read it, Chair. It says intelligence might be gathered by covert or overt means from a range of sources, human and non-human, open or secret. In addition, there is a wide variety of intelligence forms, including political intelligence, economic intelligence, technological and scientific intelligence, military intelligence, criminal intelligence, and counterintelligence. Each of these is characterized by its seeking out and processing a certain type of information and may place different emphasis on the methods to be used.
And then over the page, Ambassador, the paper touches on the distinction, which I believe is important in your approach, between intelligence on the one hand and policy making on the other hand, and there need to be some independence in relation to policy making on the part of the intelligence structures. Would you explain that, please, to the Chair?
Yes, I can. I will try. You cannot separate the two. You cannot separate intelligence from policy makers because one informs the other. We gather intelligence through various means, secret or open. We do analysis independent from policymakers. And then we alert the policymakers of the intelligence that we collect. And this is the general norm. There is nothing secret about it, Chair. It's a global activity. All intelligence do it. And that dynamism between the two is very, very critical. And if there is a disjuncture between the two, then problems might start for the country. And I think we will come to this part.
You mentioned in consultation the duty to tell the policy makers what they need to know, not what they want to know. Perhaps you could expand on that.
The principle, there is an inherent acceptable principle that you don't tell policymakers what they want to hear. You tell them what you know, not what they want to know. Because otherwise, if you gravitate into that situation, then the policymakers are going to be dictating terms to you what to collect and what not to collect, which is dangerous.
Right. We'll get to a practical example of that interrelationship in due course. The purpose of intelligence in the white paper is set out at paragraph 3.2.3. And the first bullet, we're still on page 93, Ambassador, the first bullet.
I'm there.
What does that say?
It says one of the purpose of intelligence is to provide the policymakers timeliest, critical, and sometimes unique information to warn them of potential risks and dangers.
And are those only military risks and dangers?
Not at all, they are not. Within the context of the philosophy of this new dispensation that was created, you're talking of both your traditional, that is your security, military risks, but also your human security risks. Today, if I may just cite an example, COVID-19, the coronavirus, will fall under the ambit of your human security because it's not your traditional security. In the past, intelligence officers would say, no, that is the matter for the health department. But in the new philosophy that was created in 1994, those risks, advocate, they include human security risks. That's why I'm making an example of the pandemic that makes us now to wear these masks.
Yes. What about risks to the economic well-being of the country, economic risks?
That is why we are tasked, we just read, we are tasked to look at political, economic, technological. Look at, again, if I make an example of COVID. COVID is not only a health risk, but it's also an economic risk. Global economy is going to shutters because of COVID.
Now, that suggests to me what you say in terms of the scope of intelligence. That suggests to me that intelligence or an intelligence structure would need to be populated by personnel with different categories of expertise. Because, for example, I take it that the skills and expertise that may be required for the intelligence service to pick up the threat posed by COVID-19 at an early stage and warn government would require certain expertise which might not necessarily be the same as the expertise required to pick up military dangers and so on. Am I correct in thinking that that's what would be required?
No, yes, you are correct. You are absolutely correct, Chair. But also, where those skills are not there within intelligence, there is a scope, and again, the Constitution provides for relationships. Actually, I don't know, again, but I think in the Constitution there is a chapter that deals with the importance of interrelationship between various spheres of government and various departments.
Yes, yeah, there is.
You
Yes. So you, in other words, where you don't have a particular expertise within intelligence, such expertise may be accessed from other government departments if necessary.
Absolutely.
Yes.
Because they already have the know-how, number one, but
Yes.
also they have the budget to do that,
Yes,
which
yes.
intelligence did not have at the
Yes.
time.
Yes. Okay.
If we could go over the page, Ambassador, to the heading towards a national security doctrine, page 94. Again, we've touched on this earlier. This part of the intelligence white paper deals with the shift from the traditional and narrow approach to security to a more comprehensive approach to security. Perhaps you could explain or read onto the record the third paragraph onwards, the third, fourth, and fifth paragraphs at page 94. Do you have page 94 there?
And if I'm there, Chair.
And the heading towards a new national security doctrine.
Yes. It says in recent years, there has been a shift away from a narrow and almost exclusive military strategic approach to security. Security in the modern idiom should be understood in more comprehensive terms to correspond with new realities since the end of the bipolar Cold War era. These realities include the importance of non-military elements of security, the complex nature of threats to stability and development, and the reality of international interdependence. This more comprehensive approach to security is also endorsed by organizations like the UN and the OAU. This approach is inter alia reflected in the Kampala document of the OAU of 19th May 1991, where a process was set out in motion known as the Conference on Security, Stability, Development and Cooperation in Africa, CSSDEA. The purpose of this document was providing a comprehensive framework for Africa's security and stability, and measures for accelerated continental economic integration for socio-economic transformation.
And the last paragraph, please.
The intermingling and transnational character of modern-day security issues furthermore indicate that solutions to the problems of insecurity are beyond the direct control of any single country and cannot be rectified by purely military means. The international security agenda is shifting to the full range of political, economic, military, social, religious, technological, ethnic, and ethical factors that shape security issues around the world. The main threat to the well-being of individuals and the interest of the nations across the world do not primarily come from a neighboring army, but from other internal and external challenges such as economic collapse, overpopulation, mass migration, ethnic slavery, political oppression, terrorism, crime, and disease, to mention but a few.
Yes, that's ethnic rivalry, I think.
Ethnic rivalry.
Right. Just to clarify what was said there. And then just the last sentence to over the page, beginning consequently, security is defined less in military terms and more in the broader sense of freedom from vulnerability of modern society.
Yes. In other words, in the words of an American scholar, New thinking on security has the following key features, which should form an integral part of the philosophical outlook on intelligence. One, security is conceived as a holistic phenomenon and incorporates political, social, economic, and environmental issues. Two, the objectives of security policy go beyond achieving an absence of war to encompass the pursuit of democracy, sustainable economic development, and social justice. Three, regional security policy seeks to advance the principles of collective security, non-aggression, and peaceful settlement of disputes.
The establishment of the intelligence structures in 1994 and 1995, were they intended to accord with these principles?
Absolutely. Absolutely, they were.
There are on page 97, Ambassador, certain basic principles of intelligence which you will touch on in your evidence, and certainly further evidence may touch on. These principles are named but not described in any detail. They're described later in the middle of that page. What are those principles?
The first principle is an integrated national intelligence capability. Integrated. It always, that word integrated, you will always see and hear it post-1994. The principle of departmental capabilities, that's when we're making the example of intelligence and health as an example. Principle of political neutrality, absolutely, absolutely critical in a democratic country for a democratic intelligence service. Intelligence officers, intelligence operatives must be political neutrality. Politically neutral. I cannot, because I am a member of the ANC, use that in my day-to-day functions, because that might be to the detriment of other political parties. That's what that...
and of the people of South Africa.
And of the people of South Africa. The people of South Africa, the citizens, are the main targets for intelligence. That is why, Chair, it is also important that intelligence must move away from that cloak and dagger thing where you wear dark glasses and overcoats. Because it doesn't work anymore. You are not going to get what you want. Because everything is on your cell phone today. You think you have information only to find out there are people who are far better off than you. There are a number of papers that have been written, Chair, on this matter. New models for intelligence, and I've promised...
well, it would be good to get some of those.
Yes, we've discussed that, Chair, and we will attempt to put together a bundle.
Yes.
And perhaps we'll be assisted by further witnesses in that regard.
No, that's fine.
But there certainly is valuable information there which may inform your findings and recommendations particularly, given the important role of intelligence in a democratic society, properly managed.
Would it be correct then, Ambassador, based on what you said a minute ago, to say that the principle of people first also applies to the intelligence community?
Absolutely.
Yes.
Absolutely. Absolutely.
Yes. The interests of the people first.
It has to be.
Yes.
It has to be.
Yes.
I will deal with it later. Chair, to illustrate my own personal preferences and why I decided to come and present myself to this commission. I was looking at myself as a South African first, because you have been mandated to look at these issues of allegations of state capture, corruption, fraud in the public sector, including state organs. How could I then say, no, this does not affect me because I'm in intelligence, unless you don't understand the philosophical basis that your intelligence has been set up. Hence, some of us, and I think I will speak on behalf of Njenje and Sheikh, we responded to the call because we understand our duties. We understand our functions as intelligence. And we are not apologizing to anybody for having been in the intelligence, but it's intelligence that is concerned with the well-being of the people and the country. That's the
Thank
principle.
you. Yes. No, thank you. I think so. That's very important.
The next principle, the fourth bullet on that page, talks about legislative sanction, accountability, and parliamentary control.
And parliamentary control. That is one of those oversight mechanisms that were set up. Legislative sanctions. Hence we have, as a country, the Joint Standing Committee on Intelligence. Accountability and parliamentary oversight. We can be called as intelligence at any time by the Joint Standing Committee on Intelligence on anything. And I'm gonna illustrate at the same time when you are confronted with challenges within your own domain, you can resort to them and seek for help. And later we are going to talk of how we tried to do that. Well, as to whether it did help. We were saying during our deliberations, also with your legal team, what is the use of this beautiful constitution that we have? These strong institutions of oversight that we have, if it does not help the people of South Africa, the people of the region, the people of the continent, and the world, what are they of use?
Well, I'm very happy that you are going to deal more with those issues, Ambassador, because as I have said publicly, part of what I believe this commission must look at is when certain things were happening in the country, and there are bodies which had been set up to exercise oversight. Where were they? What were they doing?
Yes.
Should they not come up and tell the nation through this commission that these were our obligations, this is what we did, or if they did not have enough resources or enough mechanisms, should they not come and tell us? Or should they not say, we have examined our own record against what has happened, and we are prepared to say to the nation, we have fallen short in the following respects. And we say, in order to make sure that in the future, this kind of institution or body never falls short in this way, this is what we suggest should be put in place, because we've got to be truthful, we've got to be honest. And I'm hoping that some of the leaders from different institutions will not just look at coming to the commission as a place where they must defend this or that or defend themselves, but where they will say, we believe that we are accountable, we believe that from time to time we must look at how we have performed. And in this case, we have looked at how we have performed over X number of years. We are not going to say we have done everything properly. Here is where we have gone wrong. And we accept responsibility, but we also want to make a contribution as to what should be done to make sure that this doesn't happen again. So I'm very happy that from what you have said, I can see that you will be dealing with these very important issues. Thank you.
The other principle is the principle of balance between secrecy and transparency. I think it speaks for itself,
Yes.
unless you want me to.
Perhaps it is dealt with later, but perhaps now's the time to deal with it. The principle of classification and declassification, and why the process of declassification should not serve ulterior motives. Perhaps you could touch on that, as you've told us.
I thought that Advocate Pretorius would be an expert on this now through experience of his engagement in the commission. Yes, the question of classification and declassification. There are standard norms globally. They are not the same. But norms where periodically what was secret must be declassified so that the public can have access to it. At the same time, and it must be accepted, and the public must accept it. The public cannot get everything that the intelligence services have. Otherwise, it will jeopardize the work of people, operatives on the field. That must be accepted. But there has to be a balance. That is why even in terms of the classification and the declassification, presently I am not in a position to comment as to how effective is this classification and declassification within the intelligence services is presently. But perhaps when they come here, they can be in a position, and I don't want to blame people and accuse people of doing or not doing anything, only to find out that there is a lot of work that they are doing.
Yes, I might just point out that in your statement, you mentioned that you have certain documents which are classified.
Yes.
At various levels, from confidential to secret.
Yes.
Those have, with the cooperation of the department, now been declassified. So we will provide them in due course.
That has to be appreciated. That has to be appreciated, and I'm sure key to those people would be the Minister of Intelligence, because I would have expected that she would be the one who have cited that. That's encouraging for the work of the Commission. But also, Chair, just to move a little bit, just a step back, just for 1 second. As I'm sure Advocate Erasmus will lead me, there was a sense of comfort in me yesterday when I saw the responses of some of the members of the top 6 of the ruling party, a positive mood, where openly they say to you, no, we agree with what this, yes, these colleagues, or comrades as we call ourselves, they did meet us. And of course, there's also a document, I think, in the package, where the former former commanders and commissars of Umkhonto Wesizwe constituted themselves and went to the top 6 to address the very issues that are bedeviling the country. And the top 6, members of the top 6, and I have to say I appreciate that move by them.
No, I think it's important. There is a need on all of us. There is a need on leaders or in society, leaders in the country, leaders of different institutions and organizations to seek to deal with these issues in a very honest manner, and in a manner that is constructive, and in a manner that is prepared, that shows preparedness, that there is no closing of mind to say, no, we'll never accept this or that, but to engage with a view to saying, let's see what happened, let's see how it happened, let's see where they might have, things might not have happened the way they should have happened.
Should I continue, Advocate?
Well, the further principles are largely self-explanatory, and we'll come back to them in due course, but perhaps you could just mention them for the sake of completeness.
Yes, then there's the principle of the separation of intelligence from policy making.
Dealt with that, yes.
Now this is critical, and it's not just words. It still needs to be unpacked, this principle. I've got my own interpretation of this principle, what it means, and how it should be implemented, and how it was supposed to have been implemented. And we are constantly, as individuals, interacting on this principle, informed by one element that we always ask. And I think, not I think, in Ambassador Sheikh's evidence, he flagged it. And he asked, does the country need a ministry for intelligence service? Does it need a minister? Otherwise, at certain points in time and life of the government of the country, you are going to find a discord on that principle, where a policymaker would want to interfere into the work that the intelligence is supposed to be doing, independent from him or her. We will come also to that during my
Well, I did want to say, at some stage, I do want to hear your interpretation. So at the right stage, Mr. Pretorius will lead you to that. But also, and I don't know if you deal with it in your statement, in your affidavit, also I would be happy if you are able to enrich me in terms of internationally, what is the norm, maybe in democratic societies, in regard to this principle of separating intelligence from policy making, but you can deal with it at the right time.
I will, Chair. And then there's the principle of effective management, organization, and administration. Effective management, organization, and administration. That spans through now the roles of a DG, who is the head of the department, the role of a minister, who is the head of policy and policy making, and the administration, What systems do you put in place so that there are no wrongdoings that can happen within the organization? And I think, Advocate Pretorius, we are going to be dealing with that matter?
Yes.
Because there would be examples where we show that there were problems with this effective management and administration and the organization. I'm thinking of the example would be PT1 that I know you will be dealing with. Then there is the principle of coordination of intelligence and liaison with departmental intelligence structures. Earlier on, I talked of the structures that were formed in 1994. One of them that has got that responsibility of coordination is the National Intelligence Coordinating Committee, what is called NICOC, which is administered by a coordinator for intelligence, but also the coordinator for intelligence chair another structure that is called the NICOC principles, and co-opted departments into the work of intelligence. And the principle is a simple one, that South Africa's new dispensation, intelligence dispensation, is premised on coordinated intelligence. One department, it is dangerous for one department to take a product to the president or to cabinet which has not been checked by other departments. Now, there's what is called strategic intelligence. Now, it's that coordinated package. But the system also allows, of course, for operational ones, which does not need to be coordinated. Then the principle of an ethical code of conduct to govern performance and activities of individual members of the intelligence service. That's command and control, which would lead to accountability based on ethics. So the first question that should be asked, are we ethical? Do we understand this? And what does it mean? And not only what does it mean, how is it implemented? And then the oversight bodies are supposed to be the arbiters over that control, because they should be the ones who would say, no. There's no control here. These people are law unto themselves. These people are involved in this and this and this and this. And if you have unethical people, then you will have an unethical intelligence service. If you have an unethical intelligence services, an intelligence service can coup a president in a country or can cause mayhem in the country. So it's absolutely important. I'll pause there, or should I continue?
Thank you. If we could go to the next page, where there are three principles set out, that under a democratic government, those agencies entrusted with the task of intelligence work should agree to execute their tasks in the following manner. What are those 3 points?
The first point, as the white paper says, Chair, they should accept as primary the authority of the democratic institutions of society. And those constitutional bodies mandated by society to participate in and or monitor the determination of intelligence priorities. 1. They should accept that no changes will be made to the doctrines, structures, and procedures of the national security framework unless approved of by the people and their representative bodies. They should bind themselves to the contract entered into with the electorate through a mutually agreed set of norms and code of conduct.
Of course, does the fact that the intelligence community operates, at least to a degree, in a confidential or secret framework, affect the need for a strict code of conduct?
Come again, Advocate?
The need for a code of conduct, is that affected by the fact that intelligence operatives operate largely in secret?
Partly yes and partly no. I'm saying no, and I think I like using the phrase, the jargon of the Americans when they talk about people who drafted these documents. They call them the framers, our framers. But the people who drafted these white papers and this legislation, one of the other things that they had in mind, they were informed, of course, by the history of the country. We know that intelligence and security services during apartheid time were a hand unto themselves. That's why the creation of your flag pluses, your kufuts, your what, they were not accountable to anybody. They had that in mind. And of course, that's why I was saying yes or no. Because if everything is locked up in vaults, people will not know what is happening. And it's not necessary for everything to be secret in intelligence, no.
Well, I'm not sure whether my and your understanding of Mr. Pretoria's question is the same, but I understood him to be asking the question whether the fact that intelligence operates largely in secret justify the proposition that there should be no code of conduct. That was my understanding. Was that your understanding as well?
No, it was not, because there is a code of conduct.
Yes, okay, Mr. Pretorius, did I misunderstand?
Well, perhaps I should put it a little more bluntly,
Yeah.
if I may, that the need for a code of conduct is even greater where people operate under cover of secrecy. That's the proposition I was putting.
The need, come again.
The need for a code of conduct,
yes,
and a strict code of conduct which is enforced, is greater where people operate out of the public eye. That's something we can debate.
Yeah, well, let him say something, because maybe his answer that he gave you earlier on wasn't an answer I expected from him. That's why I'm following up. Let me tell you what I'm thinking.
Yes.
On my understanding of his question, as I articulated it, namely whether the fact that intelligence operates secretly justifies that there should be no need for a code of conduct. So, having understood the question in that way, which might not have been correct, but his follow-up seems to suggest I may have been correct. Your answer to say yes or no, I didn't understand correctly, because I would have thought that the need for a code of conduct is justified everywhere. But the actual content of the code of conduct may be informed by the nature of the operations involved, but that there should be a code of conduct should not be in dispute. That's my thinking.
I agree with the latter part.
Yes.
It should not be in dispute. But also number two, it is not everything that is in the domain of intelligence, in practice, in day-to-day practice, that is in secret. It is not. Let me cite an example of an activity that we got involved around about 2003, 2004, when we were developing a national security strategy. That process was an open process. I was leading that process during that time. We collaborated, one with business. We collaborated with the Human Rights Committee. He's an advocate now, Copeland, eh? When he was chairman of the...
Yeah, he's a judge now, yeah.
He came to make a presentation. The hearings were not being conducted at the farm, but they were at CSIR. People from the Institute of Security Studies, who's the guy heard there, he came to make a presentation. NGOs, because we were cognizant that the development of national security is not an exclusive domain of us. We cannot develop a national security alone. So that's why my yes or no. But it is true that there are those activities that are secret. And there I will go into a trench and say, there have to be those. It cannot just be open, everything open. Otherwise, why do we have an intelligence organization?
Okay.
But we can still debate this thing outside and beyond the I see Advocate Pretorius is smiling.
If we go to page 99 over the page, you've told the chair that in 1994, 1995, there were two major intelligence structures, one domestic and one foreign. If you could just please look at the second last paragraph on page 99, which begins the most significant departure from the old dispensation.
Yes, a very important principle, and it tends to be forgotten. It says the most significant departure from the old dispensation, that is the apartheid dispensation, is that instead of two centralized civilian intelligence organizations.
Well, the document says one instead of one.
Instead of one centralized national intelligence organization. Remember, in the old dispensation, you only had the National Intelligence Service. Now, this line says a departure. There will be two. Hence the creation of your National Intelligence Agency and your South African Secret Service. Right? This arrangement will not only ensure that the new intelligence dispensation in South Africa corresponds with general international trends, but will promote greater focusing, effectiveness, professionalism, and expertise in the specialized fields of domestic and foreign intelligence. The services will have distinct intelligence mandates and line functional responsibilities and will share essential support services to avoid costly and unnecessary duplication. They will accordingly create appropriate liaison mechanisms to deal with areas of mutual interest.
Chair, I see it's 1 o'clock. I'm not sure what your intention is with the long adjournment.
Yes, we'll take the lunch adjournment, but I just want to find out whether Ambassador Maqetuka has any constraints in case, I don't know, you have a better idea, in case we have got to go beyond 4 o'clock to finish?
Yes, we have been dealing with that issue in the limitation of flights.
Yes.
But may I just ask him,
Ambassador, what is your situation?
No, my situation is fine, Chair.
It's fine.
I don't have any time constraints. We can go even if we go up to 12.
Okay, no, thank you. So if we need to go beyond 4 o'clock, we will go because I'm available, and it's important that if we can, we get all of this evidence today.
Thank you.
Okay, we'll take the lunch adjournment and we'll resume at 2 o'clock. We adjourn.